Hello, YouTube, my old friend. I've come to talk with you again. My name is Vince White. I'm an employment attorney. On this channel, we answer questions from YouTube users, getting folks the answers they need from an employment attorney. But not today. We are answering a question, though. We have a question from someone who will remain anonymous. I'm going to call this person a Facebook guy. Facebook guy. Facebook guy came to us from a Facebook group, which I think is a group where folks who have experienced workplace discrimination, workplace retaliation, maybe some workplace sexual harassment. I'm not sure. I'm not part of the group. But it sounds like they congregate to support each other, which I thought was pretty awesome. So, Facebook guy has my email, apparently. And I do not answer questions that get emailed to me, but this group sounded really cool, so I'm making an exception. Facebook guy asked us, one of the people in the group asked a really good question, but I can't find a video on it. Her question was, if you have not settled your claim yet and you still have the EEOC investigation open, is it legal to talk to people, excuse me, about what happened in your case? For example, she is friends with coworkers and wanted to know if there's anything that would get her in trouble if she told others about her case. We had an exchange. I'm just going through the exchange to see if there's anything I should be sharing from the exchange. Only thing I'll share from the exchange. Facebook guy asked, hey, can I post your videos other places? And I said, yeah. So the videos, I create them to help people, so I don't care where you post them. Like, you can, unless they're like if you're posting it in like a clinic for like defense attorneys to be like, let's plot how to mess with people using these videos. Well, that wouldn't be ideal. But also, it's not like they're new, right? They've seen my playbook before, so I'm not too worried about it. Yeah, the videos are meant to help people. I don't really care. I'm not like giving the license away on them or anything, but I'm also not hunting anyone down who steals the videos, right? Is my take on that. So back to the question. The question is fundamentally, if you're still in the investigation phase with an EEOC charge, can you talk to other people about what happened to you? The answer is very simply, unless you've agreed not to, which means unless you've entered into some kind of contract or agreement to enforce confidentiality or non-disparagement or something of that nature, then yes, you can talk about it. The only thing left to be afraid of is if your employer sues you for defamation. So you may want to look at wherever you are what the elements of a defamation claim are. And in most states, that's going to be roughly, check your local. I can't advise you the laws of many states, right? I can advise as to the federal laws that pen through the EEOC. Excuse me, but I cannot advise you as to your state laws. I'm not allowed. The Bar Association will come and they will take me away. So check with your local counsel or check your local elements wherever you are as to what would be defamation. Generally, though, you're talking about knowingly lying and publishing that lie about your employer. So listen, can they sue you for defamation? I don't know. I don't know what you're saying. I don't know who you're saying it to. I don't know what the elements are where you are. Keep an eye on that. It shouldn't be a huge concern, but it should be something you're lightly aware of. It should be on your radar. Generally speaking, though, the answer to this question is yes, you can talk about your case if you haven't signed a contract that says that you will not. Now, one more note on this. The more you talk about your case, the less your employer is capable of purchasing your silence. That should stand to reason, but people often don't think of this, right? If you tell 30 people, 30 coworkers, what's going on in your office, your employer's going to look around and say, well, everybody knows already. So why would I pay you extra for a confidentiality agreement or a non-disparagement agreement, right? Maybe that you don't care about that. It also may be that the laws of the land where you are or the laws of this nation are changing in a way to make confidentiality agreements less meaningful. And that's a moving target. That is changing day by day. We have a lot of videos on the channel about that. New York was like, oh, you can't have confidentiality anymore in certain claims. And then that lasted about 2 months because that law was really poorly drafted, right? New Jersey, kind of the same thing. California did it, and I think it's still sticking. I haven't seen anyone with any bright ideas how to get around it yet. The NLRB, a federal agency, did something kind of like that, but we're all trying to figure out exactly what it means and if it's actually the law of the land. So, you know, pay attention to all that. It's a developing field. And it could mean, even if you did sign something, you might not be subject to that agreement not to speak about your case. But the simplest answer today, which is April the 10th of 2023, is that if you haven't signed anything, if you haven't agreed to not speak about it, then you can, but you still may not want to, and you should think about that. Good luck. I applaud you, Facebook group, for taking care of each other, and I hope this helps somebody. If it does, I got to do my things. Like, subscribe, comment down below. Helps me to help more people just like you. And remember, almost everybody works. Not everybody wins. That's for sure.